Hi, my name is Megan Lutton. I'm doing this presentation today for the Assessment 2 Legal Research Toolkit. The learning outcome of this toolkit will follow the 5 elements set out from the 6 elements that were developed by Professor Sally Kieft and Mark Israel from the Australian Learning Teaching Council Discipline Scholars of School. These 5 elements form the framework from the threshold learning outcomes for law and support the skills and knowledge required to be a successful legal practitioner. I've chosen this framework to assist me in supporting the large amount of information into a practical and logical format. I've also included a case management tool to support the IRAC model, which will be used to assist with the research skills required for problem solving and managing a case. I looked into the McRae report, which highlighted 10 fundamental lawyering skills they felt should be taught in law skills. These 10 skills are listed below. 1. Problem solving. 2. Legal analysis and reasoning. 3. Legal research. 4. Factual investigation. 5. Communication, oral and written. 6. Counselling clients. 7. Negotiation. 8. Understanding litigation and alternative dispute resolution processes and consequences. 9. Organisation and management of legal work. And 10. Recognising and resolving ethical dilemmas. Tool number 1, knowledge. I compared what was being studied in the United States against Australia's core law subjects. In Australia, we study the Priestley 11 after Justice Priestley. These subjects are shown in the diagram below, and check boxes are included for each subject to be marked off as they are completed. Tool number 2 is ethics and responsibility. The Queensland Law Society Ethics Centre defines the different legal ethic controls as being extrinsic controls, intrinsic controls, and common law. The ASCR, which is the Australian Solicitors Conduct Rules, and the Legal Professional Act 2007 have the most current Queensland State Guide to follow. For intrinsic controls, it means it's talking about personal values and principles of honesty, courtesy, loyalty, and competency form the best practice for ethical practices. Common laws found in disciplinary hearings, and they provide a discipline register. Another useful tool, I thought, is the Ethical Deliberation Questionnaire. When you're having trouble with identifying ethical issues, you can use this questionnaire to come to a conclusion, and you can also use it, if required, to back up how you came to be in that position. Tool number 3 is thinking skills. I've provided a simplified IRAC process flowchart adapted from Field and Duffy. First, you want to identify the facts by asking your client who is involved so you can identify the parties. Who suffered and how? Why was it avoidable? What is the non-relevant information? Is there any missing information? You want to include specific details like dates and monetary figures. You also need to identify the issues. You want to identify what has gone wrong. You want to name each party and note their individual issues and work out what area of law may govern the resolution of the problem. Some law examples that you might want to look into can be contract law, trade practices, company law, negligence criminal law, constitutional law, partnership law. This list is not extensive, but just lists a few areas that you may want to look into. You have to identify any conflicting facts. Next, you want to identify the legal rules that govern that issue. You set out the legal principles that will be used to address the problem and source legal principles from cases and legislation. Next, you want to apply the rules to the facts at hand. Do the facts satisfy the requirements of the law? Detail why the client's claims are or not justified based on law. How will this law be used by each party to argue their case? Use relevant precedent cases or legal principles to support each answer. If applicable, use legislation. There can be several parties involved, so examine each case individually and analyse why their claims are or are not valid. Legal principles and precedent cases are used in each analyst, even if overlapping occurs, and can be applied to both parties. Refer the reader to another paragraph in the paper rather than rewriting if it requires the same recommendation. Discuss the argumentative parts of the case and not the ones that are easy or obvious. Lastly, we want to conclude by deciding what the outcome is. Make a judgment. Close with argument which is the strongest and support it as being the most appropriate answer. State who is liable for what and to what extent. Consider how parties could have acted to manage their risk and to have avoided this legal problem. This is my case management tool that I have adapted to capture all the checkpoints necessary in a complex case analysis. I've just given you a screenshot of the very first page. You will see in my toolkit it is quite extensive and covers all the points you should be checking to ensure you gather all the facts correctly. Tool number 5 is about communication. It's about knowing your audience, using the right language register, being prepared, having personal presentation, good listening skills, and good questioning skills. This toolkit is extensive, but I feel that over time it will become more concise as my knowledge increases. I see it as being a dynamic document that will evolve as I do.